So good afternoon to you all. It is my great pleasure today to welcome Professor Matteo Bonelli to Fabra University. He did his PhD at Maastricht on the topic of union of values, safeguarding democracy, the rule of law, and human rights in the EU member states. And he has conducted postdoctoral research at NYU, Milan University, Bocconi, and he's back to Maastricht now. Actually, we tried to attract him here to Fabra University with no success. But
yes.
Great. At least we have him here today to discuss the issue of the Court of Justice and the role of the Court of Justice in safeguarding judicial independence. He has written extensively about that, so the floor is yours.
Yes, thanks a lot for the invitation. I'm really happy to be here to discuss judicial independence with you. It's really a pleasure. So I will now sometimes look back so I can also see my my PowerPoints. But maybe you can go directly to the first. The second slides. Just click whatever. Yes, exactly. So the paper I'm presenting today is actually something that I'm co-authoring with Monica Klaas, who is my colleague in Maastricht. And we're writing this chapter for a book on revisiting judicial politics in the European Union. This follows a previous volume that Mark Dawson, Bruno De Witte, and Elise Muir wrote on, or edited on judicial activism. It's not judicial politics. So, and as I will say, it's not exactly the same thing according to them, and I agree. So, but basically what we want to do in this paper is to show how the Court of Justice has been, well, a highly political actor in the context of the judicial independence case law. So it's judicial independence before the Court of Justice, but I focus on this little paper. So no worries. So with political actors, to summarize the arguments, we mean essentially that the court has stepped into a field that the rule of law that seems to be mostly something for the political institutions. In fact, if you look at the instruments, one instrument that the EU has to protect its values, Article 7, this is essentially political instrument with the court playing a very minor role. And it has done so by offering what we and then many also have defined as really creative interpretation of EU law, in this case law, starting from, as I will explain in a moment, the famous Portuguese judges case, but also, for example, in the Repubblica, this Maltese case where the court developed or created this principle of non-regression on the rule of law. Judicial politics or being a political actor means that it doesn't always mean that the court has pushed further its case law. On the contrary, at times it has also been much more careful and much more prudent in what it has done. So it has opened and closed the doors, and I think more generally managed the EU strategy of protecting rule of law and judicial independence. And finally, and I will focus on that in the last bits of the presentation, the court has reacted to contestation coming from domestic constitutional courts, or generally maybe domestic constitutional players, by not taking a step back, but actually going even further. You can go to the next, thank you. So very briefly, because I think many of us have seen enough of the Portuguese judges case, we'll come to the judgment of 2018, February 2018. On this austerity case, in fact, it was mostly an austerity case, but this started as an austerity case back in 2016-17, where the court gave this very broad interpretation of both the scope of application of Article 19 TEU, which goes beyond, let's say, the traditional scope of EU law and covers all national courts, which may potentially decide on issues of EU law, and also a broad interpretation of the substantive content of Article 19, which crucially includes also judicial independence. Now, if you read Article 19, it doesn't necessarily live there. There is no reference to judicial independence. There is nothing that really says, well, the provision has a broader scope of application of the rest of EU law, so to say. And in fact, if you then also look back at the position of the Advocate General in the judgment or the position of the Commission, they also suggested a much more traditional and conservative reading of the provisions. The court nonetheless goes further. It puts in place this broad construction, again, on the scope of application and of the substantive content of the provision. And with Monica in a previous contribution, we really suggested that this should be read against a broader political background. So you cannot understand the judgments if you don't consider context. The court saw basically how political actors were struggling in rule of law protection, and it decided to put forward this construction to offer a new platform for enforcement of judicial independence judicial independence principles and the rule of law. Yeah, so the court really steps into this battle. The next. And I think what happens with the Portuguese judges is really that a new phase, a new chapter in the rule of law crisis opens. Soon after, the Commission starts its first infringement actions based on Article 19, essentially in the case of the Polish Supreme Court, but then also a plethora of other actions. We'll see them in a moment. And perhaps more surprisingly, this was not what the court expected, I would say. Many national courts also start asking questions of interpretation of judicial independence standards to the court. Questions both on Article 19, but also Article 47 of the Charter. Now, we argue that this is really a game changer in the sense that if the court at the beginning of the rule of law crisis was really only a marginal player, it had decided the small infringement actions against Hungary in 2012-14, after the Portuguese judges case, well, I think the court becomes the central actor and really guides the strategy to protect the rule of law and judicial independence. So we can move to what happens after. So the core of this paper to look at judicial, judicial politics and the judicial independence case law. Now, if we look back at the Portuguese judge's case, I think there was also a lot of unclarity. So the court reaches this bold judgment, but it leaves questions to be tackled in its follow-up cases. I think, again, a bit intentionally, it's may have to always read intentionally what courts do, but of course, not everything could be solved back then. And it leaves itself room for, again, other political and strategic choices. We see in the progression of judicial independence case law, the court carefully alternating more bolder decisions and more prudent ones. So in that sense, and I want to clarify this, that being political does not necessarily mean being always activist, expanding his jurisdiction over member states' actions. But at times, it might also mean taking a step back and leaving certain questions to national courts or to the political process. Yes, so I then analyzed two sets of cases, or we analyzed two sets of cases. The first is infringement actions based on the Charter. I won't spend too much time on this, but I think the Commission has, since 2018, started 5 actions based on Article 19 TEU, all against Poland, which is in itself remarkable. It seems to be the only case in which there are judicial independence issues. The first 3 Supreme Court, ordinary courts, and disciplinary regime have been decided by the court. The other 2 are pending. The last is the most recent one, and it's a bit different, as I will explain later. And what we see is that the court really believes that 258 is the best platform for EU intervention in protecting judicial independence. So here the court can, of course, directly assess whether national measures breach EU law standards. So it can apply its standards. There are clear consequences that are set out. Of course, the system of Article 16. So a member state, if there is a breach of EU law, must remedy that breach, and if it does not, financial sanctions can be imposed. And the court has also worked, let's say, around this to boost the effectiveness of its own decisions. In a parallel case also concerning Poland, it's called the forest case because the name of the forest is unpronounceable for non-Polish. It has delivered remarkable interim orders and tried to boost the effectiveness in general of its decisions, also allowing the position of penalty payments for the non-compliance with an interim order. In preliminary references, can go to the next, thank you. I think we see a much more prudent court. Now, here we have seen dozens really of cases. Poland, but also Romania, Hungary, and even cases from Germany and Italy. There is also, I think, a Spanish one on remuneration of judges, and also these mutual trust cases. So quite a few cases coming from national courts. And here, of course, the mandate of the court is fundamentally different, because in preliminary references, the Court of Justice is, so to say, only or formally only called to interpret EU law, to set the standards. We see several signs of caution by the court. For example, the court has used a fairly orthodox approach to the admissibility of preliminary references. So in a few cases, the court has rejected questions coming from national courts because they were not relevant for the specific case pending before the national courts. The court has used what colleagues, well, actually the court itself, but what colleagues have described as the appearance of independence test, which means that the court only sets the standards, the Court of Justice only set the standards on judicial independence, and then the national courts are to apply them. And crucially, what they have to verify is whether the national court in question or the regime gives an appearance of independence to, let's say, a reasonable person. And the court has at times really also highlighted this distinction of tasks that the court has under 258 and 267. So there is some criticism, but I think the approach of the court is formally and legally correct. Yes. So these two, as I was saying earlier, can be seen as a caution, as a sign of a political court, of a court that's clear, let's say, it's the action of the institutions towards preliminary references, towards infringement procedures wherever it's possible. And in general, it's also carefully managing the influx of cases. So the court, I think, was concerned that too many questions might come on the question of judicial independence. So this is why there's adopted this line interpretation of admissibility. And also, I think there is a concern, especially with the appearance of independence, for domestic judicial, established domestic judicial independence arrangements. So, for example, in the Maltese case on Repubblica, where this NGO challenged system of appointment of Maltese judges, the court really took, while it took a progressive step forward in creating this principle of non-regression, in the way in which it applies it, even if the system really is questionable, because judges are appointed by the Prime Minister of Malta after an independent examination of the body, but still that, you know, it's a regime that is certainly questionable. The court takes a step back because I think it shows concerns with established arrangements which have been considered already sufficient to fulfill EU law and ECHR standards. So I think in this sense, there is, I think, a discussion in this country also on judicial independence arrangements. I think if the questions would come before the court also would be careful in what it is saying about this possible controversial cases. So we see in general a balance of more prudence and bolder judgments. So especially in references, the principle of non-regression, as I mentioned, of the fact that a member state might not diminish the level of protection of rule of law that a member state has, that a candidate country has at the moment of accession, is a bold judgment in itself, but then in the way in which this is implemented in follow-up cases, then this is used only to support conclusions reached on the basis of other provisions. Okay, now this is a section we still have to write, so we'll not spend too much time on the pushback, but in general, there has been quite a bit of resistance and contestation to the court cases. I think especially two constitutional court decisions, one in Poland and one in Romania, have been often mentioned in this context. Broadly, we see in Poland a question of the new judges, so the judges appointed after, let's say, the Law and Justice took power, have refused implementation of the court ruling, and the Polish Constitutional Tribunal in K321 has fundamentally challenged the primacy of EU law and the case law of the court under Article 19 EU. The Romanian decision is not as bold, but also rejects some of the in part the authority of the court and the principle affirmed in important, this is the first case on Romania decided by the Court of Justice. We also see more attempts not only by courts, but also of legislators to reduce, let's say, the autonomy of national courts and judges to refer questions to the Court of Justice or to then apply the case law of the courts in their decisions. So I think it's mostly, I think, these three countries, Hungary, Poland, and Romania, where we see the strong resistance. I want to say something more on then the reaction to the resistance, which is the final part of the paper, and I promise I will concentrate on that, so I'm happy to see that time to do so. Okay, so the first thing to be said is that the court seems to be very much aware of domestic contestation, right? So again, we see in the sense of political actor, in the sense of an actor that is aware of what others are doing and reacts to it. And I think what we see in particular is the court developing its reaction in two pillars. One, the second goes a bit beyond the judicial independence case law, but it's still related to it. So the court does two things. The first is it connects different dots that we could already find in its case law, but it connects different discourses. Judicial independence under Article 19 is seen together with the traditional question of primacy of EU law, and also the rights of courts under the preliminary reference procedures. Of course, nothing or very little is fundamentally new, but I think what is new is how the elements are connected. Of course, for example, if we look at 267, the preliminary reference, we already know cases like Cartesio and so forth, or Metti and Appellee, so where the court had already protected the rights of lower courts to refer questions to the Court of Justice and to use the case law of the courts. But now this is seen together with the principle of primacy and this application of conflicting national law, and it is framed as an issue also of judicial independence. The second answer of the Court of Justice is the court is dealing with more possible than actual national identity objections. So, of course, this is not, again, nothing new because the court has already dealt with many national identity cases, but it's using the judicial independence decisions to also say relevant things on how to use and how not to use Article 4(2) of the TEU, the National Identity Clause. Okay, so I think I focus in particular on 2/3 judgments. So these are the judgments in the Romanian cases. And in particular, just to give a bit of context, in Romania, there had been a first decision, so it's a set of cases. It's a very complex factual setting, which I will spare you from. But basically, what happened after the first judgment of the court in 2021, the Romanian Constitutional Court had rejected the interpretation offered by the Court of Justice. Soon after, there is also the judgment of the Polish Constitutional Tribunal, not related, of course, to the Romanian context, but also so to give the full context. And then when the court gets to decide its Eurobox, so this is the second set of Romanian questions relating to judicial independence reports. It already had to deal with this contestation of its first decision in the Romanian case, as well as more broadly the Polish, but also the German cases. The first thing the court does of decision, which has not been discussed a lot in the debate, but it's a very fascinating decision, is that it takes the opportunity to reaffirm the principle of primacy of EU. And the way in which it does so is extremely interesting, because first the court maps its standard case law, right? So fundamental laws and Costa Enel and Siemens. So that, EU law has primacy of the national constitutional law, so on and so forth. Now, of course, the issue of the principle of primacy traditionally is not only the contestation of domestic actors, but also that it's a court creation, right? It's not written anywhere in EU primary law that EU law has primacy. And we know this is also not that the member states have, forgot about it, but it was a conscious decision by the Lisbon Treaty not to include primacy, which would have been included by the Constitutional Treaty of Rome. So I think what the court does is that it tries to find hooks in EU primary law or the declarations which are not part of primary law, but they are attached to the treaties, to establish its own view of absolute primacy as, let's say, the correct legal interpretation of EU law. So next to the references to the traditional case law, we see two elements in particular. One is as far as I could see from the Curia website, an unprecedented reference in the court decision to Declaration 17 attached to the Lisbon Treaty, which says that the Conference of the Member States recognizes the case law of primacy of the Court of Justice and of direct effect. Of course, the declaration is not legally binding, but the court refers to it as one of the legal foundations of primacy in EU law. And next to it, the court also refers to Article 4.2 of the TEU, not the national identity part, but the member state equality part, as again another legal ground for primacy. The court says the Union can respect equality of the member states only if the member states are unable, under the principle of primacy of EU law, to rely on a unilateral measure, whatever its nature. So it rejects the idea of counter limits of unilateral derogations from EU law. It's very interesting also on a sociological perspective, because the court here takes an argument that was made by its presidents, Kuhn Lennart's in academic writings, and it was mentioned for the first time in this press release after the PSPP judgment of the German Constitutional Court. So from academic writing to a press release to now the court case law. This is not the focus on my of my piece, but it's a very interesting story that I think other colleagues are telling in this book. But anyway, so the court tries to find these new hooks, these new textual grounds for primacy in EU. The second element is then a strong defense of the position of national courts and judges. So, yeah, it's a long quote that I will not read, but basically here the court connects the both. EU law is primacy, judges must be independent. As a consequence, the possibility for national judges to disregard national law completely with EU law, so this application and to give full effect to EU law is a guarantee. The possibility to do so is a guarantee that is essential to judicial independence. So again, primacy, it's mostly primacy, not primacy and its application are a guarantee, are part of judicial independence, or vice versa. So I think this is a clear response to the position of the Romanian Constitutional Court that has denied the compatibility of the law courts to rely on the EU law, on the case law of the courts against their own Constitutional Court. And yeah, it's another sign of the court that sees the context and acts to protect its allies, the lower courts, and fights against its, let's say, enemies, the National Constitutional Court. The court is also more precise and says, in particular, and this was what happens from other things in Romania, but also in Hungary and in Poland, the disapplication of national law can never lead to disciplinary liability. Again, it's a connection between disapplication and judicial independence, which disciplinary proceedings are part. Now, the Constitutional Court of Romania issues a press release. Again, this is another interesting story after the judgment of the Court of Justice and continues to challenge it, right? So it says, well, this does not change our position. And the court then, in a third set of cases, has an opportunity to then further expand on what already said. So this is the RS judgment. It's a third wave of many cases. Here, and I will not say much more on that, but basically RS repeats the doctrines of primacy affirmed earlier by Eurobox. And then it's interesting because the court really phrases, it really connects it up explicitly by saying that primacy together or in conjunction with Article 19 preclude practices which limits the power of national courts to examine the compatibility with EU law of national legislation that in particular was found by the Constitutional Court to be in line with the solution. So any national court at whatever stage of the proceeding should always have the possibility to say EU law, national law is incompatible with EU law, I should be applied and apply instead EU law standards. Yeah, there is, I think, another, yeah, so again, the court is very explicit. The Advocate General was even more explicit in saying the power of this application to give full effect is, again, a guarantee essential to judicial independence. And it was the Advocate General said the second subparagraph of Article 19 is a concrete manifestation of the principle of primacy of EU law in its EU. So, strong connection between judicial independence and the preliminary reference procedure and the beauty of this application that follows for times. Again, we see, yeah, we can do this a bit more. Yeah, okay. So again, we see in this judgment, in this response, clear signs, in my view, of political court. So what is remarkable is that if you look at the preliminary reference requests of national courts, when in none of the two cases an answer to primacy was really necessary. There was very little in the references themselves on primacy. And in fact, if you look at the opinions of the Advocate General, excluding the last elements that I just mentioned, especially in Eurobox, Bobek said very little on primacy. We see reliance on new legal grounds, so developments of the primacy doctrine, and again, this protection of the position of national judges. I think in a way this sets a bit the scene also for a pending case, another pending case in the Polish context, the one on the Polish Constitutional Tribunal. I said earlier I would say a bit more on this, but in that judgment, this is a bit different compared to previous rulings in infringement cases, because first, here the Commission is challenging, let's say, the very composition of the court. It is saying the court itself does not comply with judicial independence standards because of the problems of appointments that are quite well known. And this is the first dimension. The second dimension is that the Commission in its infringement action has not only made arguments based on Article 19 of the EU, but it has also questioned the judgment in K311 on primacy. It says, well, primacy is the general principles of EU law. If a member state court does not respect it, we can start an infringement action. Now, this is not the first time because there was the action on PSPP vice against Germany. But anyway, I think the court needs to find a textual hook for the principle of absolute primacy, so to say, in EU law, in order to then be able to implement, to adopt that principle in an infringement action, right? So, rely on an unwritten principle in an infringement case would be quite difficult. So the court puts in place this construction also to build, I think, towards that judgment. So it wants, it is taking the opportunity to find a clear legal basis in EU law for the primacy principle. I move to the conclusion because I want to leave enough room for the discussion, of course. The second element is the national identity. So here again, we see two components, two subcomponents to it. The first is, maybe it's not the second. No, go ahead. So, yes. So the first is the court has for the first time identified or begun to identify the union-own constitutional identity. So this is not in a judicial independence case law, but in the decisions on the validity of the budgetary conditionality instruments. And then the court says that the rule of law and the value of Article 2 are an integral part of the very identity of the EU as a common legal order. So there is this language of the identity for the first time used to describe the EU itself. And in the same judgments, because there is also the parallel action in Poland, the court also says, well, these values can never be derogated, even for national identity reasons. So it's true that Article 2 allows for diversity, but it doesn't allow derogation from the common values. So the member states must respect at all times the obligation to protect the rule. The second dimension, which is more evident, I think, again in the RS case, is on how to use this national identity clause, which has been there since Lisbon. The court has used it at times, but it has never been fully clear when and how national courts can use it. Here, the court really sets out first that national courts can never use it as a unilateral derogation clause, something that was, it's a given. But it was never said so explicitly, I believe. Second, that they should always send preliminary references to the Court of Justice before this application. And it will be the court to say, well, what national courts can do, or even check the validity of the law. So it requires dialogue. Some concluding ideas. Again, the conclusion is still written, it's bullet points. So first, let me repeat what I stressed. This is, I think, in the judicial independence case, we see a very political court. Some might call it activist, but I think it's a bit more. I think activists can be a bit, first, necessarily critical, and second, a bit reductive, because the court has been activist many times, but other times it has exercised also judicial restraints in a sense. So I think what we see in particular is is a court that is not passive rather than activist. It's an active and not activist court, because it really creates this entire doctrine of judicial independence on its own, right? It takes a case in the Portuguese judges, which seem to be about austerity measures, and it makes it into judicial independence case law, creating an interpretation of Article 19 that then paves the way for infringement actions and for preliminary references. And then it continuously steers EU actions, so it steers the Commission infringement procedure, and it also explains the national courts handling use of Article 19. The court is also political because it doesn't decide simply on a case-by-case basis, let's say, but it acts in context next to other players, the Commission, but also national constitutional courts, in the sense that it monitors their reaction and then counter-reacts or pushbacks. So to conclude, this is also my second presentation of the week here in Spain on Friday. So I think what we see is this judicial independence as an important vector and moment of constitutionalization of the EU structure, with the EU stepping in, and especially the courts, into areas that were traditionally considered to be of national competence, and fleshing out the common standards. And so if we look on a case-by-case basis, we see a developing set of common principles on judicial appointments, the role of national councils of the judiciary, irremovability of judges, disciplinary proceedings, and many, many aspects of governance of judicial independence. And it's even taking this as an opportunity to boost the primacy of EU law. Now, at the same time, we have to be aware, and we have to keep in mind that it's also a platform, let's say, for contestation. So I think K321 of the Polish Constitutional Tribunal is really the most remarkable challenge to primacy of EU law and to the authority of the court we have seen, even more than the German cases. And the court is also boosting, the Court of Justice is also further boosting this contestation, really going for a direct confrontation with national players. And if at times the court has also taken step backs, I think that, for example, the Tarico Saga was a case in which the court avoided direct confrontation with the Italian Constitutional Court. Even in the German cases, there has been, at least at EU level in general, a bit more prudence. Here we go for direct confrontation. And I think we will have to see, especially with the judgment in the Polish Constitutional Tribunal case, whether this is a moment more of rupture of recomposition. And I think the political context, especially with the Polish elections also next to the Spanish election coming in the second part of 2023, will tell us a lot whether we are more of a moment in which there is risk for the authority of the court and the authority of EU law, or whether we go towards a progressive recomposition in parallel also to the measures taken under the conditionality regulation, which at the time seems to be perhaps the most effective tool for the response to rule of law and judicial independence backsliding. Yeah, I think I will conclude it here, and thanks a lot again for the invitation. I look forward to the discussion.